Welcome. Thank you so much for watching. Each year, the Supreme Court issues dozens of judicial opinions that impact our lives and those of future generations. Some, like the anticipated ruling on Dobbs expected to overturn Roe v. Wade, precedent established nearly a half century ago, which gave women the right to seek an abortion, attract understandably great attention. But other cases deserve our focus as well. For a variety of reasons, faith in the court is declining. It is therefore especially timely that we consider why the court matters as a vital institution upholding our democracy. Shortly after assuming office, President Biden established a presidential commission to explore possible reforms. These included term limits for justices, the composition of the court, such as expanding or packing the court, and looking at issues that perhaps some would argue blurred into responsibilities that normally are held by the legislative branches. To discuss this and much more, I'm so pleased to welcome Stephen Vladeck. He is a professor of law at the University of Texas School of Law, and he has argued over a dozen cases before the U.S. Supreme Court, the Texas Supreme Court, and he's also testified on several congressional committees talking about the role of the Supreme Court. He's also CNN's lead analyst on the Supreme Court. And just yesterday, Steve, I had the opportunity to listen to your podcast, NSL, National Security, National Security Law Podcast. And it is, I just loved it. And you do that now with the Dean Designate, Bobby Chesney, Dean Designate at the University of Texas Law School. And it is right there with my favorite podcast now. So great to have you with us. I'm sure you have a lot of fun doing that. It's probably a little different from standing in front of a bunch of eager law students.
Yeah, but it's all the same idea, Jim. Just, trying to sort of break down the big issues of the day in a way that's accessible to folks who don't spend quite as much time nerding out about them as I do.
Well, that's one of the things we try to do here with the McCuistion program as well. So as I mentioned, poll after poll is showing that support for the Supreme Court, faith in the Supreme Court appears to be flagging. And my goodness, that recent leaked opinion of Justice Alito has probably just exacerbated and accelerated that situation. What is the impact of that on, for lack of a better term, the institutional norms of the court?
Yeah, I think there's no question that the leak of the draft opinion in the Dobbs case, the other leaks that have clearly happened surrounding the result in the Dobbs case, that this is really a both terrible moment for the internal dynamics of the court and a pretty powerful symptom of things that have already gotten quite bad behind the scenes at One First Street. This is an institution that historically operates under very strong norms of collegiality, that even when the justices are fiercely disagreeing with each other, they're still friends and colleagues, and that they're able to work together because of that. And, we're seeing both explicit and implicit signs, Jim, that that's just not the case now, and that maybe that wasn't even the case before the leak happened in early May. And that's problematic in multiple respects. It's problematic for the court's ability to do its job, and it's problematic for our ability as the public to have faith that the court is acting the way it historically has, right? As an institution that's not necessarily above politics, but an institution where it's not politics all the way down, right? And I think that's the concern that the leak in many respects amplifies.
You just said something that caught my attention. You said other leaks. Were there other leaks beyond the Politico one?
There certainly seem to have been. So about a week or a few days before the Politico bombshell, back in early May, the Wall Street Journal ran an editorial speculating that Justice Alito had the majority opinion, that it was 5-4, that the majority was perhaps softening, that Chief Justice Roberts was trying to pick off maybe one of the other justices in the majority. That certainly looked, after the draft opinion leak, like maybe it wasn't speculation. A few days after the Politico story, the Washington Post reported the details of the justices' internal deliberations at their private conference in December, where they had first voted on what to do in the Dobbs case. Of course, Jim, as you know, the only people in the room for those deliberations are the justices themselves. And the Post at least attributed the details of that conference to, quote, conservative lawyers close to the court's conservative justices. And there have been a couple of other tidbits that have come out of the court since then. So, depending upon how you count them, I think there have been at least 3 and perhaps as many as 5 different leaks surrounding the Dobbs opinion. Of course, the draft opinion is still the earthquake. And the draft opinion is still the one that really doesn't have any historical parallel compared to the leaks from the court before. But I think if you look at the whole pattern, I think it's even more indicative of a very, very sick institution.
Do you think that's coming from the leadership of the court? I mean, does Justice Roberts bear any responsibility?
That's such a great question. It's hard for us to know on the outside. Certainly, there has been a concerted effort on the right to attack Chief Justice Roberts over the last 6 weeks to 2 months. Remarkably, Justice Thomas, in public remarks at the American Enterprise Institute, actually almost went after Chief Justice Roberts by name, talking about how much better the court used to operate when William Rehnquist was the Chief Justice. That's a pretty obvious dig at the current office holder. The same Washington Post story we talked about had some of the same conservative lawyers focusing on the continuing bitterness on the right toward Chief Justice Roberts for his 2012 vote to uphold the Affordable Care Act, Obamacare, the signature domestic policy achievement of the Obama administration. So I don't know that it's fair to say that the Chief Justice bears responsibility. He has 1 vote out of 9.
So you can probably make a pretty good argument whether it's someone on the right or the left who did the leak. But let me ask you this. Is the leaker in jeopardy, any legal jeopardy? Did they break a law?
Almost certainly not. I mean, we still don't know, 1, who the leaker is, or 2, how they obtained the document. It's possible that some violation of, for example, the Computer Fraud and Abuse Act was committed if someone hacked into the Supreme Court's computer system to take it. But, Jim, by itself, Supreme Court draft opinions are not classified information. There's no criminal prohibition on the disclosure of that kind of confidential information. So, criminally, I don't think there's any real jeopardy here. Of course, if one lies to the FBI as part of an investigation into the leak, that's a separate matter. Of course, I do think there would be potentially serious professional consequences for whoever the leaker is. But again, I mean, this is where I come back to there being more than one leak. That it seems pretty clear that there's more than one culprit here, that perhaps there's some of this coming from both sides. And I have to say, it would not shock me if one of the leakers were actually one of the justices themselves, or someone very close to the justices, as opposed to the clerks, which is where so much of the focus has been. But also if some of this is actually sort of secondhand leaks, where information was shared privately with someone who wasn't directly privy to it, and it was that person who turned around and decided to leak it. I mean, there are so many variables here that the assumption that it was a angry liberal clerk trying to, scare Brett Kavanaugh into joining the Chief Justice, or an angry conservative clerk trying to, toughen up Justice Kavanaugh into not leaving the majority. Those strike me as too simplistic. There's more going on here than just that.
My goodness, though, if it comes out and if they could really document it that it was one of the justices, that would be earth-shattering.
Well, indeed, and this is why, I mean, if I'm, Chief Justice Roberts, I'm not actually sure I want this investigation to go very well. And this just goes back to where we started, which is that, whoever's responsible, whatever we do end up finding out or not about the leak, I mean, it's just stunning that this is where we are. And that a court that was already set to hand down some of the most contentious decisions, really, of the last generation, is now going to do so over the next days and weeks against the backdrop of this additional cloud of, if not illegitimacy, at least of politicization.
Let me take advantage of your knowledge of so much prior Supreme Court cases and ask you this. In Justice Alito's draft notes, he writes that there have been some 30 decisions that have overturned precedent. And one thing that I read in preparing for our discussion is that many of these really expanded some of the rights, certainly like Brown versus Board of Education. Is that an accurate description?
Yeah, I mean, I actually think 30 is low. I mean, I think 30 is the number that number of times the Supreme Court says we are expressly overruling prior precedent. There's a implicit overrulings that happen far more often. But yes, I mean, the pattern historically has been that where individual rights are concerned, the court tends to overrule precedent in favor of expanding rights, not constraining them. There's one significant counterexample, and that's the economic rights that the Supreme Court really valued in the early part of the 20th century, something called the liberty of contract, where the court was very aggressive in striking down state and federal economic regulations that tried to adjust the relative bargaining power, for example, of employees in the workplace. But I think it's not technically accurate to say, as some do, that Dobbs, if it comes out the way we expect it to, would be the first time the court has ever overruled a precedent in favor of sort of narrowing a right, but certainly would be the biggest, and it would be the one with the most significant effects when we think about how many folks have structured their life decisions, how many folks have sort of figured out where they want to live, who they're going to work for, right, based upon access to reproductive rights and to reproductive care. And I think that's part of the story here, that frankly those who think Roe and Casey are wrongly decided tend not to necessarily give enough attention to, is just how much Roe and Casey have created what we call reliance interests on the part of those who assume it should be possible in any state in the country, especially here in Texas, to have access to abortion care.
Normally in the month of June, that's when cases are announced, opinions are announced, but that doesn't seem to be the case now. Is the court being just sort of lax, or why such a delay?
Well, I mean, I think this is all of a piece. I mean, I think the drama surrounding the leak has had a lot to do with why the court is, frankly, way behind. I mean, we hit June 1st last week, which is oftentimes a date that reporters look at to try to figure out where we are in the term. And the court on June 1st still had 33 decisions and argued cases to go. That number by itself is not the record. But when we consider how many fewer cases the court is hearing overall, Jim, the percentage is a record. So Adam Feldman, who studies this stuff quite in even more detail than I do, for as long as there's data, the court had decided a smaller percentage of its total cases by June 1st for any year on record, and that goes back to 1950. And I think that's a sign, right, of this broader sort of, the court is, things are not running smoothly at the court, and I think the weight of these significant, momentous, divisive decisions, even before the leak, was certainly playing its part in dragging things down.
Something I didn't know anything about was that Congress in 1988 gave the court freedom to establish its own docket. I wasn't aware that Congress was involved with that.
Yeah, I mean, the story actually really starts in 1925, and 1988 sort of the end of the story. I mean, so, for the first 135 years that we had a Supreme Court, Jim, virtually all of its docket was mandatory, meaning that if the Supreme Court could hear a case, it had to hear the case. And so basically the Supreme Court had no control. If it was forgive the characterization, but if it was a fairly mundane dispute between two private parties with no broader implications, but it happened to fall within the court's jurisdiction, the court had to hear it. And actually largely at the behest of Chief Justice and former President William Howard Taft, Congress in 1925 begins to give the Supreme Court control over its docket by expanding this obscure Latin practice called certiorari, which is basically a writ, an old school English writ, by which an appellate court would carry the record up from a lower court. And the idea here, Jim, was to basically say, hey, Supreme Court, your docket has gotten too full. I mean, by 1891, the court had 1,800 cases on its docket and was running 3 or 4 years behind. And so we, Congress, are going to let you pick and choose at least some of the cases that you put on your docket. That was the big innovation in 1925. In 1988, Congress went the rest of the way. And so in 1988, Congress says, actually, Supreme Court, we're going to give you almost complete control over your docket. And what's striking about that is not just how much power that gives the justices to pick and choose which cases they're going to hear. But, Jim, the justices since 1925 have interpreted that power to allow them to pick and choose which questions within those cases they're going to hear. So much so that there are times when the justices will write the question themselves and say, we are taking up this case not on the questions that the parties have presented, but on this separate question that we want to answer. And so the justices are controlling their docket, they're shaping their docket in ways that are, I think, remarkably underappreciated, even by folks who follow the Supreme Court pretty carefully, and in ways that give the court a ton of power. What my colleague H.W. Perry calls the agenda setting function of the court. And what's remarkable about all of that is that as this has happened, as Congress has given the Supreme Court more and more control over its docket, the court's docket has shrunk. Where every year the court is hearing fewer and fewer cases. So,
but let me interject here and say this is a natural segue to one of your favorite topics, I think, and that's the shadow docket or emergency powers.
Yeah, I mean, so what this is, I think these are related, maybe not, causally, but at least chronologically, right? Where since you mentioned 1988, which was the last major time Congress adjusted the court's jurisdiction. In 1988, the court was still hearing, Jim, about 150 cases a year. When I was in law school in the early 2000s, it was still 85 cases a year. This term, it's going to be 59. Last term, it was 56. The term before, it was 53. So, we're under 60 now, and under 60 for the first time since the Civil War. Well, what is the court doing with all of its new free time? And I think part of the explanation here is the rise of the shadow docket, the rise of these other cases, these other contexts where the justices have been increasingly busy. And just, the difference for folks who don't follow the court as closely as you and I do, when we talk about sort of the big cases the court decides, the Dobbs case, the New York Guns case, those are cases where the court has granted certiorari, so agreed to take up the full appeal, where there's multiple rounds of briefing, where there's a big oral argument, and where there's, a lengthy, detailed majority opinion and concurring and dissenting opinions that come down when the case is decided. The shadow docket is everything else. The shadow docket is the court's orders. It's the orders granting or denying certiorari. It's the orders granting or denying emergency relief while a case works its way up to the Supreme Court. So putting a lower court decision on hold.
In these cases with the shadow docket, there's no explanation. You don't know how people voted.
So there's always been a shadow docket. I mean, the Supreme Court has always had orders, right? It's always had the very first order of the Supreme Court on February 2nd, 1790, was an order saying, hey, we don't have a quorum, we can't do any business today. So historically, there's been no rationale, there's been no vote count. But Jim, historically, we haven't cared because most of these orders are anodyne, because most of these orders just don't affect us. Maybe they affect the parties. And what has really shifted in the last 5 or 6 years, and it's actually what I'm writing a book about, is that the court is using these orders in contexts that have much more significant substantive effects, not just on the posture of the case the court's deciding, but on you and me, on all of us, right?
Give me an example.
So the Texas abortion ban, right, the SB 8, it was the Supreme Court on September 1st last year that allowed that ban to go into effect by refusing to block it on the shadow docket. Alabama redistricting, right, after lower courts had blocked the congressional maps that the Alabama legislature drew in January of this year after the 2020 census. The Supreme Court stayed that decision on the shadow docket without telling us why, right? Basically allowing Alabama to use in the 2020 midterms these congressional maps that lower courts had found to be unlawful. And just, we're seeing this in the COVID context, right? Where the court on the shadow docket has blocked New York and California COVID restrictions, where the court on the shadow docket blocked the Biden administration's vaccination or testing mandate that the Occupational Safety and Health Administration was proposing to apply to all large employers. It's just so much stuff, Jim, that's affecting so many of us. That's now coming through these orders.
I think this is quite concerning. What can we do about it? Is this, again, the role of Congress?
So, I mean, I do think this, and this I think is a consistent theme in the story, right? Which is, you mentioned 1988. And I do think it's a real problem that since 1988, Congress has basically gotten out of the business of having a conversation with the Supreme Court about its docket, that really for the first 200 years of the Supreme Court, there was this healthy, long-standing back and forth institutional dialogue about what the court should be doing with its time, about how it should be spending its time. Congress now thinks that's not its job anymore. So yes, part of this should be Congress, but Jim, frankly, I think part of this has to be us. That I think the public really has, and I think some of this is the media's responsibility, sort of been distracted by the big glitzy cases, So a good example from last term, right? There were tons of stories about the case of the cursing cheerleader, right? A pretty modest First Amendment case with really very few broad implications for anybody else. But there were dozens of media stories about this school that punished a cheerleader who cursed on social media. Meanwhile, right, there's very little discussion of all of these orders where the court was, affecting how states were doing their COVID mitigation. And so I think part of it is, yes, we need Congress to get back into the business of thinking that the Supreme Court's docket is part of its job. But we all need to understand that, like, the Supreme Court is doing a heck of a lot more than just those big, headline-grabbing, socially divisive cases that we see the decisions in every May and June.
It really reminds me, and I wish we had more time to talk about it, is how Congress, I think, has shirked its responsibility on the authorization of use of military force.
That's one of my sort of fields of interest, as you know, and I think that's exactly the right analogy, that this is sort of an area where the Constitution presupposes, as Madison said in Federalist 47, that ambition would be made to counteract ambition, that the branches would be pushing up against each other to try to claim power. And I don't think it should surprise us, even if it bothers us, that the fact that the political branches have stopped pushing against the courts has left room for the courts to claim a lot of power that perhaps we're not comfortable with them exercising.
So you've touched on this, but if someone said to me, why should we care about the Supreme Court? What's my elevator speech?
I think the elevator speech is because the Supreme Court, for better or for worse, is increasingly a part of our lives in every way that matters. Right, the OSHA vaccination or test rule, like that case affected, Jim, 83 million Americans. What our states can do when it comes to abortion, that's up to the Supreme Court. Social media, the Supreme Court just had a case a few days ago about Texas's attempt to ban content moderation by large social media platforms. That affects all of us. So, we may not be parties to these cases, but the Supreme Court, for better or for worse, is now being asked to decide, Jim, so many of the central social debates in our political culture. And so I think so long as that's going to be the case, we all have a vested interest, not just in who's deciding these cases, but in how they're being decided, even if we agree with the bottom line, that the process matters because it is the process. It is the notion that these are, legal actors and not just political actors that leads us to have faith that the court is actually a judicial body and not just another lever of partisan political power.
So you've talked quite a bit already about how this court is different from prior courts. Let's say that you're in a classroom in 50 years from now. How will historians look at this court, especially perhaps this year?
I don't think there's any question that we are at an inflection point in the history of the U.S. Supreme Court and the history of the court's relationship with the rest of our constitutional system. We have not had a court this one-sided ideologically since the 1930s. And that was itself, an inflection point in the Supreme Court's history. I think a lot depends on what happens in the next 5 years. Are we going to look at this as a brief aberration, or are we going to look at this as the beginning of a fundamental shift to an era where the Supreme Court was ever more dominant, even as it really is in many respects more conservative than the American population as a whole? And so I think, it's hard to know where this train is going. But I think there can be no question that we are at a critical moment in the history of the U.S. Supreme Court, the likes of which we haven't seen probably in at least a generation, if not in several lifetimes.
So that brings us back to President Biden's commission. Is that just going to sit on a shelf?
I think so. I've been fairly critical publicly of the commission because I think in an effort to tackle, you mentioned some of the topics at the top, in an effort to tackle the really, really dazzling big stuff about adding seats to the court, about term limits, I think the commission missed a really important opportunity to actually educate the public about what the court does on a day-to-day basis, to answer your question about exactly how the court affects us, and frankly, to propose common sense reforms that would not be nearly as politically toxic as changing how justices are appointed or how long they serve.
What do you stand on term limits?
I could live without even talking about term limits if we had a serious talk about jurisdiction, if we had a serious talk about which cases the justices are hearing and what we expect them to do when they hear them. And this is perhaps, I think, the last point I'd like to make, which is, it is possible to believe that the court is getting a lot of these cases wrong, and still think that it's really, really important for the court to be doing a better job of convincing us that even the wrong answers are in good faith, that even the wrong answers are coming from a place of neutral judicial principles, as opposed to just, hey, we have the votes and you don't.
So again, from your vantage point as a scholar who looks at this every day, is the court more political, more polarized now than it's ever been?
I think it is certainly as political and as polarized as it's been in any of our lifetimes. And I think that the big difference between today and prior periods of extreme politicization is that the polarization today maps perfectly onto the political divisions of our society in a way that historically they did not. So the court has been this divided historically. The divisions have never before so neatly mapped on to the divisions that we all are encountering on a day-to-day basis. And I think that's exactly what lends to the concern that the court is just reinforcing what is a political divide and not necessarily a legal one.
Well, Professor, that is a sobering conclusion, very sobering, but I want to thank you so much for being with us, and I want to thank all of you for watching today's program. And as I think Steve really underscored, we need to get involved. We need to ask more about these issues. And as always here at McCuistion, we're talking about things that matter with you, people who care.